Good evening to you at home, and thank you so much for joining us. Of course, you can live stream on our website. That's ann7.com/live TV. My name is Cindy Mabi. Good evening to you. Now, reports suggest that President Jacob Zuma submitted fresh representations to the National Prosecuting Authority on why he should not face corruption charges. The National Prosecuting Authority gave the president until today to make representations on why the charges against him should not be reinstated. This after the Supreme Court of Appeal upheld a High Court ruling that the decision to withdraw the charges against Zuma were irrational. And the charges relate to Zuma's alleged involvement in the country's multi-billion rand arms deal in 1999. And the possible reinstatement of charges has brought into sharp focus the integrity of KPMG's forensic audit into Zuma's finances. And the audit was conducted by the same person who compiled the report on the so-called rogue unit at the South African Revenue Service. KPMG withdrew that report in September. And speaking to ANN7, NPA spokesperson says, and I quote, a new team of senior prosecutors led by the Director of Public Prosecution in KwaZulu-Natal is set for vetting of charges, and a team will consider the matter in its entirety and recommend the way forward. And old members who looked at the charges 9 years ago are no longer with the NPA, and the team will have to look at the affidavit and go through all the documentation before any decision is made.
Well, legally speaking, it's never too late to bring an allegation or to bring a court finding. It's never too late to charge any individual, according to the South African Constitution, as long as you have evidence, regardless of how many years that case has been extended or that person has not had his or her day in court. However, this matter is strange because President Jacob Zuma has been ducking it for many, many years, and I don't think anyone brought any fresh allegation on why to charge him. This is concerning the 783 charges, or the so-called 783 charges against him for, corruption and racketeering. The NPA arguing now for 18 charges makes a defining picture, puts a defining picture to this allegation and to this case. To say it was never 783, it's in fact 18. Now, the NPA must then see if it will reinstate 18 charges and then charge him for 18 charges, which I think is unlikely at this point. Number one, the people who were in this case have, many of them have left. They were old judges and prosecutors who were not in the case anymore. Some of the people who testified against the president are no longer available to testify against him. What's surprising in this matter is that these are cross funds that entered or exited in his account at a certain point in time. Now, that does not mean that there are 783 charges. It just summatively means that there has been about 783 transactions which have been made. Now, no one else is cited in this case, as in to say who was, providing the money or what happened in the president's finances, and we still don't have the core matter of evidence. So it also seems like it's a political swipe for the Democratic Alliance to drag the sitting head of state to court, to perhaps embarrass him, and to score some political points.
And having made its submissions, the Democratic Alliance says a new and relevant submissions by President Jacob Zuma should be considered by a court of law and not the NPA. The DA claims the impartiality of the National Director of Public Prosecutions, Shaun Abrams, has been questionable on numerous occasions in this matter. And the DA wants the NPA to share Zuma's new representations with all parties, including the DA, and the parties must be given 14 days to comment.
As far as we're concerned, the correct procedure to be followed is that Advocate Abrams should charge Mr. Zuma. He should be brought before a court. He should be formally arraigned. He should then have the opportunity to make such representations as he might make, and then for the National Director to consider those representations. But it was a point made over and over and over during the 8.5 years where we were taking this matter through the courts, that it is actually at the trial court that must decide on the merits of a charge, and not some public official This is the situation in both South African law and international law, and we do not believe that it should be decided by officials. It should indeed be decided by a properly constituted trial court.
And the key question in this matter is it in the interest of justice to charge Jacob Zuma 10 years after charges were brought against him? And joining us in studio is Jackie Shandu, a political analyst, Professor Sipho Siepe, also a political analyst, and via Skype we have our analyst, Richard Chamali, a legal strategist. Good evening to all our guests, and let me also welcome Paul Ngobeni, who's a legal expert on the phone line. Thanks so much for joining us. Let's just start with you, Professor Siepe, for obvious reasons, your intricate involvement, if you want to call it that, and to this particular matter, an executive summary, just to refresh us. It's been 10 years. You know, memory lapse and all sorts of things. Bring us up to speed as to where we are.
Yeah, first of all, you are quite correct that some of us were interested in the case. But our interest at that time was based on the issue of justice. If you remember, at that time, people like Zolenzima Vavi and the COSATU were raising the issue of trial by media. And this is what was happening. And we actually felt, and I still feel, that it is not correct to try somebody through the media. And the president has been subjected to that. As we speak now, for most people, the president is corrupt. You don't need the court to find that. It's already established because of this repetition. And as you were also indicating, the notion of the notion of 703 charges is something that had been put out there. And some of us have always argued that most of the people who are in prison don't have a mass meeting of charges. They have 1 or 2 charges. And when I asked one of the judges at that time that what does it mean to have so many charges, he said no, but once you have so many charges, you should know that it means that the state does not have a case, that it is unsure, that this is what you call zama-zama. You try too many things and hope that somewhere, this is a fishing expedition. And Jesse Duarte put it very nicely. He says the nature of the justice system in our country is that you have a crime committed, then you look for the suspect. In this case, you had the suspect before you could find the crime. So they had to look for the crime. So this is why every time something comes, there's an excitement. So this president has had a rough time. But most importantly, most people have said the president must have his day in court. What they don't tell you is that he did have his day in court. This case, one of the judges said it has linked from one crisis to another, for the same reason that we actually were raising. But when you ask some of the members of the ANC who were behind it, they were telling you that, no, we don't want Msholozi to go to jail. We simply don't want him to be a president.
But in the interest of justice, though, and again, where you're saying that the narrative that has been peddled and perpetuated is that if you connect the dots in certain appointees that President Jacob Zuma had made was essentially to cushion himself, to make sure that his day in court does not happen. In your view, will this be an opportunity, at least for the president, to answer to these questions?
Before he comes in, I think what we need to do, we want a prosecution agency that is without blemish. What we found in this case is that even people who were no longer members of the NPA, who were there, who had left, were influencing the process. That can't be right. So we should not say justice is good for all of us, but when it comes to other people, injustice must be allowed because it is the people that we dislike.
All right, Mr. Chamali, thanks so much for your time. Just in your view, whether President Jacob Zuma, if or the charges would be reinstated, whether he'd have a fair trial, considering the whole bravado around it and the controversies and the trial by media, etc.
Well, I think in the court system itself, I'm relatively certain that he'd have a fair trial. I think the biggest issue, as you rightly point out, is the trial within the media, because a lot of the media, a lot of people and a lot of political organizations want to see Msholozi nailed. And it's likely that he will, considering that the corruption charges and the other person, it takes two to tango, Shabir Sheikh in this matter, was found guilty on those corruption charges. So it's likely that Msholozi will be found guilty as well on the same set of facts. It's just now a matter of whether or not, as you put it, it will be in the interest of justice. And I contend that it doesn't matter how long it takes to get your day in court. Once you get your day in court, you need to appear for it.
All right, Mr. Paul Ngobeni, legal expert, good evening to you and thanks so much for joining us. Is it your view, as Professor Sipho Siepe alludes to the fact that seemingly there's been an attempt to shoot at a moving target with all these numerous charges without any substantive one having the possibility of sticking?
Well, I think that is correct. 700 and something charges, just that for starters, it's just startling. It makes no sense. And if they had as easy a case against him as your last guest just stated, why has it taken so long? Wasn't it the prosecutor that in 2003 said that they had a prima facie case, but they did not think it was winnable in court?
Mr. Shabani? Yeah. Oh, sorry. Carry on, Mr.
Yeah. Didn't they also appear before a judge who condemned the prosecution for procrastinating, for wasting time, for not being able to get it right? Didn't they also appear before Judge Nicholson, who found that there was political interference in the prosecution of Jacob Zuma? The SCA, after having overturned Nicholson's judgment, was left red-faced because just 2 months after the SCA judgment, then the spy tapes were revealed, which shows that Nicholson was correct in the first place. Justice Nicholson was correct in finding that there was indeed political interference. That is something that cannot be denied now. So when you're talking about fairness, whether it's fair to bring Zuma to trial now, all of these things, all of these procedural missteps by the state, by the prosecutors, have to be brought to the fore. And I would just conclude by saying that, in fact, I think all branches of our government, the parliament, the executive, as well as the judiciary, have failed Jacob Zuma at every step of the way. There can never be justice in this case.
Please stay on the line with us, Mr. Shandu. Your view on this matter, considering all the technicalities and procedural flaws that has brought us to this day. You think this is something that the NPA would find worthwhile in prosecuting?
Look, I must also begin by just highlighting the fact that in the history of the modern legal system, as we know it across the world, I have not heard of someone being charged on counts of 700 or more charges. It even looks practically impossible to commit that number of transgressions or criminal activities. But of course, we're here today that actually it's 783 transactions, which means if you are charged with theft and you've stolen from a company 5 or 6 times, it's still one charge or one crime of theft. So again, this is deliberate coverage, misleading coverage on the part of the media, so that it even plays into our imagination that this guy is just the king of criminals across the world if he's able to commit so many criminal charges, more than 700. So we know that that does not exist. So I want to agree also very strongly that it is not just Parliament and the judiciary that has failed the president. It is the media. And so you're the so-called fourth estate of society. So all institutions of the state that have been unleashed, we remember Mshe within the NPN saying, look, it's untenable, this thing, there's evidence, Bulelani Nguga coming in. This was meant to actually direct the outcomes of the 2007 Pulukwane conference of the ANC. It was meant to try and put a particular outcome there. So there's no doubt that there has been political meddling, interference from the very beginning. The question remains, whether in court or elsewhere, is justice able to be served? And if you ask me, I don't think so.
Yeah, Mr. Chibali, before we come to you, Professor Siepe, Mr. Chibali, your view, and especially if you're looking at the number of charges where we can just say almost as a blanket statement that it is around corruption, racketeering, laundering, but what are the actual charges? I mean, if we now reducing it from 783 transactions to 18, of which maybe 1 or 2, who knows, would be able to be prosecutable?
Well, it's the nature of the legal system to charge every interaction or engagement as a separate charge within the same case. And it's incorrect to say that there hasn't been as many charges in other cases. I recall off the back of my head, in February in Johannesburg, there was a case of child pornography where a man faced and pled guilty to 800 charges. And it's for each and every individual picture that he owned. And similarly here, every transaction, every time money changed hands, that acts as a separate charge. So it can be condensed. And it's just not, because that's just the nature of the legal system. But I understand, and I do take the point that the media likes to make a big deal out of it.
Okay. Professor Siepe?
First of all, in a court of law, there are no 783 charges. So let us debunk that as nonsense that had been perpetrated by the media for their own agenda. Secondly, I get worried when we try to undermine the role that the powers that be must project. We expect that when you are going to be the NPA, where you're going to charge people, you yourself, your hands must be clean. And this is what happens all over the world. Actually, there was a senator in the United States who was convicted until it was pointed out that the prosecution did not do its job correctly. And even then, the information that they withheld was not sufficient to make the person any less guilty. But the prosecution and the court felt that it cannot be right. So we must not, because there's a clamor of noise, undermine the precept of justice, that everybody must be treated as innocent until proven guilty. But secondly, when you have noise like that, because I also don't believe that the President Zuma will get the justice, even in the courts. You had the Shabby Sheikh, where there was Squires who made a statement that says, where he found Shabby Sheikh guilty. And the court did not even read Squire's judgment. Instead, they relied on the media, that there's a corrupt relationship. And Squire said, but I have made that judgment. I don't remember that statement. So you tell me, who influenced all those judges? Who should have read the document? Because if they had read the judgment, they would have found
there isn't a line that says there's a generally corrupt relationship, therefore...
No, it was not even there. It was something that was crafted by the media. But the judges, influenced by the media, simply leapt on that. So when you have almost an injustice even in the process, you should actually be concerned. And I do think that I'm really disappointed when I hear people saying, if the process is wrong, we should actually accept it. The reason why we have power that must be checked is precisely because the power has an effect of bringing damage to individuals. And the second thing that I would like to raise, when you discover, and it's not even challenged, that there were people who used to be in the NPA who participated in the preparation of the prosecution, that can't be right. So we must actually be, if we want to talk about justice, we must look at how justice must work. And I don't think so. But I also don't think that the courts, having seen what I have seen, will actually deliver justice. I think Nicholson was actually correct. He says, if you connect the dots, you realize that there is a political involvement, there is an interference, and therefore justice cannot be served.
Mr. Ngobeni, just from a legal point of view, procedurally, with the Democratic Alliance calling for a court of law to investigate, peruse the new submissions by President Jacob Zuma, as opposed to the NPA in making their consideration to reinstate or not to reinstate, is that procedurally permissible?
No, it's absurd. What the DA is arguing is actually, they're trying to sideline Sean Abrams because they don't like him. But in our system of justice, prosecutors have a wide discretion to decide what charges to bring, when to bring them, and what charges to abandon or to drop. That is a discretion, wide discretion, that belongs to the prosecution and does not belong to the judiciary. Secondly, there is a presumption that a prosecutor making a decision, a charging decision in a case, will act in good faith in exercising his discretion to make that charging decision. You cannot presume that Abrams, simply because of the politically motivated attacks that have been directed at him, that he will not act in good faith. There is a presumption there. It's a legal presumption that he will act in good faith. And if he doesn't act in good faith or act irrationally, well, the DA and other political have a right to bring him to court, to take his decision up on review. But he must be allowed to make that decision. That discretion belongs solely to him, doesn't belong to the judiciary. No judge can tell him what charges to bring and when to bring them, and what charges to abandon.
And are you of the view that he's executed his duties accordingly, his fiduciary duties, with regards to this matter, considering the growing call for the reinstatement of the charges?
Well, the problem is that the man, Abrams, has not even been given a chance yet. Remember that the case, all along, was up on review. This was Mche's decision which was being reviewed. Abrams had not exercised any discretion with regard to the prosecution or non-prosecution of Jacob Zuma. So we are not even in a position to say what he would do. All we are doing now, we are speculating. But I just want to caution everybody that prosecutors across the world, at least across the English-speaking world, enjoy wide discretion in making charging decisions, in deciding whether to prosecute or not to prosecute. And there is also a legal presumption that the prosecutor will act in good faith when exercising that discretion. So what I'm hearing from the DA is a lot of political noise, but there is no legal substance to what they are saying.
All right, Mr. Chamali, your view in whether prescription can be made by political parties or any other vested or stakeholder in how the process should unfold, why then would they make this kind of call if it's legally not permitted?
Well, I actually, to be honest, I have no idea. I think if they want to make this call, then they should rather opt to bring a private prosecution, which might be a better option for them. But to call upon the breach of the separation of powers and effectively tell the courts that they must direct to the prosecution authority, hey, come and bring this case to us or don't bring this case to us, that's rather absurd. What should rather happen is the prosecution authority should make the decision. The DA or any other interested party can then come and say, well, what were your reasons for that decision? And they can challenge that on review if they wish. If they're not happy with it and it's still regarded as rational, then they can bring a private prosecution. But to get the courts involved at this juncture, I don't think that's overstepping the boundaries.
Okay, and in come KPMG, of course, and that brings a completely different dynamic to what the fresh representations would be from the president, of which we're not aware of. But in your view, that would be something that could put a spanner in the works for them.
This is an institution, KPMG, that has lost all credibility, you know, and it's just going to be very difficult to rely on, you know, some of the work that they had provided previously, dating all the way back. So it also then adds to the complexities in terms of trying to get to the bottom of the issue and delivering justice, you know, arriving at decisions that are fair, that are not biased, that are impartial as well, that you have to use some of the work that had been provided. But again, we've come to know that KPMG has been naughty and there's been a lot of things that have been going on there. So the question then remains, the admissibility, the validity of the work already provided, were it not also in the same way that we had seen in terms of the media reports with Bell Pottinger and KPMG. So I don't know. I think, honestly, this case should just be buried and life should go on. I don't see it possible because you have, I mean, as Paul Ngobeni was correctly pointing out, that the courts cannot be just instruct the NPA, but because you have a political party that does not like the NPA, or at least the person that leads the NPA They are even wanting to now somewhat go around that institution and say, because we want the courts to get involved, let's even defy even a constitutionally provided institution like the NPA.
Yeah, the enthusiasm and celebration being premature, of course, based on what the SCA had said, that the decision to drop the charges was irrational, did not necessarily mean an automatic reinstatement. Professor Siep.
Yeah, I think this is where you see the dishonesty, generally, by political parties, even by those in the ANC who dislike the president. You have them saying the KPMG has lost all credibility. But on this one, because it serves their political interest and agenda, it's okay. But there's another element. The public protector did find before that the President Zuma's rights were violated. And now that we have a court judgment that came from Uganda, then the question arises that if the Constitutional Court said the remedial actions and findings are binding, it will be necessary, even before the prosecution continues, to address that matter. That are you going to say the public protector that says his rights were violated is no longer material because it involves Jacob Zuma. So there is also a challenge there. And those remedial actions and those findings have not been reviewed. So I think the president must be able to raise that issue that nobody has questioned. And actually, even in any other representation, the violation of his rights.
Yeah.
So
Professor Siepe, we are out of time indeed. Thank you so much, gentlemen, for your time. Professor Sipho Siepe joining us in studio, and Jackie Shandu, political analyst, Paul Ngobeni, a legal expert on the phone line, and Richard Chimali, legal strategist via Skype. Much appreciated. And you at home, thanks indeed for watching. We'll be back after this.